All right, welcome everyone. If you're gearing up for the Queensland bar exams, then you are in exactly the right place. Today, we are opening up the barrister's toolbox, the one for ending proceedings early under the Queensland UCPR. These are the tools that really separate the good advocates from the great ones.
So let's start with a crucial question. How do you actually win a case before it even gets close to a full trial? Seriously, mastering the answer to this is what our whole explainer is about today. And it's not just about winning, it's about saving your client a huge amount of time, money, and stress.
So here's our game plan. We're going to break down the key tools you'll find in Chapter 9 of the UCCPR. Think of them as essential instruments for your practice. We'll cover the big hammer for when the other side is just delaying, the precision scalpel for those cases that are doomed from the start, and the strategic pressure of a formal offer to settle.
Okay, Section 1. Look, litigation is so often this long, drawn-out, costly marathon. But Chapter 9 of the Uniform Civil Procedure Rules, the UCPR, well, it gives you the power to turn that marathon into a sprint. Or even better, end the race before it even starts. And this is exactly why Chapter 9 is so incredibly powerful. It's your key to running strategic, efficient litigation, because it gets right to the heart of the UCPR's core philosophy. I'm talking about Rule 5, which is all about facilitating the just and expeditious resolution of cases with minimal expense.
Right. Let's get into our first tool. This is the hammer. This is what you bring down when your opponent is just dragging their feet, failing to move their case forward. We're talking about Rule 280. So, at its core, Rule 280 gives a defendant the power to apply to dismiss a proceeding for what's called want of prosecution. You should think of it as the ultimate penalty for when a plaintiff's delay has just become completely unacceptable.
But hold on, before you can even think about swinging this hammer, you have to prove to the court that it even has the power to act. These three preconditions, right here from Rule 280, subsection 1, they have to be met. This is what triggers the court's discretion.
Now, once that power to act is triggered, that's when your real work as an advocate begins. You have to persuade the judge. Your entire argument is going to be built on these 12 factors from the leading case, Tyler v. Custom Credit Corp. You need to commit these to memory. They are absolutely critical, both for the exam and for your future practice.
Remember that number, 12, and remember the case name, Tyler. Your whole submission under Rule 280 is going to hinge on how persuasively you can apply these 12 factors to your client's situation.
But, and this is a really important but, remember this crucial balancing act. As this classic quote shows, the courts are there to decide the rights between parties, not just to punish them for procedural mistakes. This means your argument under Rule 280 can't just be about pointing out the delay. You have to convince the court that the delay is so prejudicial that a fair trial is now impossible.
Okay, let's move on to our next tool. If the want of prosecution rule is a heavy hammer for delay, then summary judgment is more like a surgeon's scalpel. It's designed for these incredibly precise strikes against cases, or even just parts of cases, that are fundamentally flawed and, frankly, doomed to fail. Now, this scalpel comes in two forms, and you absolutely need to know both for the exam. Rule 292 is for the plaintiff to argue the defendant has no real prospect of defending the claim. Then you have Rule 293, which is the mirror opposite for the defendant, but the goal for both is exactly the same, to show the court that there is simply no need for a trial.
Burn this phrase into your memory. This is the very high threshold for both Rule 292 and Rule 293. It's not about a case just being weak or maybe unlikely to win. No, the court has to be completely convinced that the claim or the defense is so weak that it has no real prospect of success. It's a high bar for sure, but when you can meet it, it's an incredibly powerful way to end litigation.
All right, our final tool isn't about getting a judge to throw the case out directly. Instead, it's about applying powerful commercial and, let's be honest, psychological pressure through the risk of adverse costs. We're talking about the formal offer to settle under Part 5 of the UCPR.
You have to understand this. An offer under Part 5 isn't just a friendly letter. It is a formal, strategic weapon. It's designed to force the other side to very seriously consider settlement, because rejecting it carries the risk of paying a very heavy price in legal costs down the road. And this slide, this is where the teeth are. This is the sting. Under Rule 360, if a plaintiff makes a reasonable offer that the defendant foolishly rejects, and then the plaintiff does even better at trial, well, that defendant can be on the hook for indemnity costs. That is a huge penalty. And Rule 361 gives a similar, though slightly different advantage for a well-pitched defendant's offer. This is how you force a reality check on the other side. So we've got the hammer, we've got the scalpel, and we've got the strategic pressure of costs. But knowing what the tools are is only half the battle. Let's talk for a moment about how you actually master them.
Here it is. This is the single most important takeaway from this entire explainer. These rules don't operate like a vending machine where you just put in the facts and an order pops out. No, every single one of them, every one, depends entirely on a judge's discretion. Your knowledge of the law gets you in the door, but it's your advocacy, your ability to persuade, that's what wins the application.
And we'll end with this thought for you to take with you into your studies and eventually into your practice. Mastering this toolbox isn't just about knowing what's in it. It's about developing the wisdom, the tactical judgment to know which tool to use and when to use it. That is the art of being a barrister. Good luck with the exams.